Hello, my name is Ben Joseph. I'm a retired Vermont trial judge. This is the Judge Ben Show. This, I think, is the 10th or 11th show in a series of programs that we've taped here at Channel 17 on involving personalities and issues that face the court system in Vermont. It's my great pleasure today to have Amy Davenport here. Judge Davenport is the Chief Administrative Judge for the trial courts in Vermont. And as such, of course, she's got an ongoing interest in treatment programs and some things that I've talked about in previous shows with other guests. I wanted to do a quick kind of who Judge Davenport is.
Okay.
Okay. So you were appointed as a judge by, when were you get on the bench?
I was appointed by Madeline Cunin in 1990. I was the last appointment that she did, and was on the bench as a trial judge from 1990 until 2005. And then in the fall of 2005, the Supreme Court appointed me to my current position, which is the Chief Administrative Judge for the trial courts.
Well, you sure paid a lot of dues before you got that job.
Well, and that's probably important in my current job because if you don't have a lot of experience on the bench, it's hard to be effective in doing this job.
Well, and this job is, you've told me, is defined by statute and rules.
And rules, and it's first of all, I have to say it's a really wonderful job. It's
Good.
Completely fascinating, but it is a bit amorphous, and there are some very concrete things that I do as part of this job. And fortunately, I have a wonderful assistant, Vicky, who helps me with those, with all of those. But so one of my major jobs in Vermont, we have 30 trial judges, and trial judges in Vermont rotate, as you may well remember, and on a generally speaking now on an annual basis. Back in the what some might call the bad old days, it was like every 3 months, but now it's basically the assignments rotate once a year, and with some judges will stay for an additional year, but that is in and of itself a new assignment. So each year I propose a schedule of assignments. The judiciary is kind of on a school calendar, if you will, because the new assignment starts, for whatever historical reason, I'm not sure what it is, the beginning of September. So as the kids go back to school, the judges go to their new assignment. And so in the spring of each year, I propose to the Supreme Court a full slate of assignments for the judges, which they either approve, or if they have issues with one or more of the assignments, they'll send me back to do something a little different. So far, knock on wood, things have gone fairly smoothly in that department. In addition to that, my duties include judicial education. So I'm very involved in judicial education programs within state, as well as judicial education programs. Because we're a relatively small state, we cannot cover all of our educational needs for judges within the state. So we also from time to time send judges to out-of-state programs. I cover that part as well. And then I have responsibilities in the area of case management, working with both judges and court staff, court managers, to help improve case management in the court system. And case management in the court system is everything from scheduling to basically how cases are handled. When do they, for example, if a case is going to go to the treatment court, how does it get to the treatment court? What's the process? And it requires keeping tabs on how we're doing in terms of prompt disposition of cases, and looking at finding problem areas where perhaps we're not doing as well as we should, trying to figure out why, trying to improve the the case management processes in that court. In that area, currently, I have significant responsibility right now for a new case management system that we are in the process, the court's in the process of building to replace our somewhat aging case management
Is this part
system.
of the restructuring process?
No, but it just has happened that it's happening at the same time, and is in many ways the efficiencies that we will gain from a new system were certainly taken into account in terms of the restructuring process. But it will allow us to do things in a more paperless way. It will allow us to use it will allow litigants to be able to file with the court electronically. It will allow us to be able to view documents electronically, and basically I think will be far superior to the system that we currently have. That, however, has to be built piece by piece, docket by docket, so that it actually, a divorce case flows differently from a criminal case. And so you have to build a case management system that actually will deal with a case appropriately given the kind of case that it is.
Is this going to involve like scheduling, how long it'll take to get something disposed?
It will definitely involve scheduling. For the first time, we'll have we'll be scheduling off of a statewide calendar. So you will know if you're a clerk in a courtroom and you go to schedule attorney A, and that attorney has a hearing in another county, you will know immediately, and obviously not schedule a conflict.
I have many times gotten letters saying that that case you scheduled, oh no, he's got a conflict somewhere else.
Right, and we have that problem now, and it's basically you can only see the conflicts within the county that you're in, but most of our attorneys practice in more than one county.
Exactly.
And we have litigants who have court proceedings in more than one county. So for the first time, you will be able to see everything that's going on in the state. And be able to schedule based on that. You will be able to pull any case from any place in the state. So it's a pretty dramatic difference from what we have now.
So there'll be a computer terminal set up in the courtroom, and if there's a question as to when it can be scheduled, someone can find out right away if there are conflicts.
Absolutely, absolutely. And the judges will have their own page, if you will, which will tell them every case that they have under advisement, every case that they have scheduled. They'll know in advance, and they'll be able to pull that case electronically and prepare for that case 2 or 3, 4 days in advance, however that happens to work out. Now, we can't do that because you have to go and you have to pull a paper file from some filing cabinet somewhere, and with all the thousands of cases we have, I don't know any judge who knows how to. You have to go to the clerk, you have to ask the clerk to pull that particular case, and which is fine if it's 1 or 2 cases, but if you're asking a clerk, gee, next Friday, I have a whole list of, I have 20 cases scheduled. Now I'd like to, I have some time right now, I'd like to review all 20 of those cases, so I'm prepared for next Friday. Can't do that. I mean, basically, other than making the clerk go and pull every single one of those 20 cases, which would take probably about a half an hour of their time. So it's, once you can view them electronically, it's amazing the kinds of efficiencies that you can build into the system, and it also, I think, makes the workload for the judges makes that much more manageable.
Well,
we'll see.
We'll see.
Right,
We'll see.
right.
But in the midst of all this, I think the public should understand there's quite a few judges who don't just sit in one court. I mean, they're going to spend 2 days here and 3 days there, and then the odd day somewhere else. Is that something that's being taken into account, or?
Yes. Yeah. No, because you will be able to access the system statewide. Currently, out of the 30 judges that I assign, there are probably 3 or 4 assignments that are like that, because you can't quite get the right amount of judge time with just, for example, with just one judge. You might take a county like Orleans, for example.
Oh, I remember that.
You remember Orleans,
Yes,
right?
I remember that.
Right.
Yes.
Okay.
Someone sent me there once in a while.
So Orleans is what we call a multi-jurisdiction court, and one judge would do all the civil, criminal, and family. But Orleans is a little bit bigger than a one-judge court. It needs a little bit more time than just one judge
really
can
does.
give it. So basically, it needs about one and a half judges. And so two other judges, actually two other assignments, give some of their time to Orleans to fill up that extra. So as I said, we have about 4, you happen to get one of them, but we have about 4 assignments that are like that, where it's, then we have other courts where it's one judge is a little bit too much. In Grand Isle, for example, it doesn't need a full-time judge.
Oh, clearly.
It needs maybe about 20 to 30% of a judge's time. So then you've got to fill in with other assignments. So it's a tricky process.
I know, who's it? One of the new, Judge Tomasi is in Grand Isle.
Judge Tomasi, yep.
And he also sits in, he makes Newport trips.
He makes some Newport trips, right?
And he goes, I'm sorry, is it Addison?
No, I think that is Judge Mello is doing that. I think he's doing some Chittenden Superior work.
Oh.
He's a judge who just came on the bench. He has a civil background. I wanted to give him, I basically fashioned his assignment in part because he's a new judge. So I wanted to give him a little feel for all of the different in his first assignment, put him in, give him some civil, which is what he's comfortable with, or what he's going to be most comfortable with, but also by giving him the Grand Isle slot, he gets a chance to do a little family, a little criminal, and gets some experience in those newer dockets.
I've sent him quite a few forms in the criminal docket, so I'm hoping it'll help him.
Yeah.
Yeah.
No, he's, so we just got 3 new judges at once, so that was quite that's unusual for us. That's an unusually large number for us.
Well, I just think it's, well, you know what I think. I think it's a very tough job, and I think one of the real problems has been time to prepare, time to prepare. I think a lot of people have the impression that the trial judges are only working when they're sitting in the courtroom.
Right.
And that's certainly not so.
Right.
I wanted to ask you about, let's see, we did this outline thing. There are statutes and rules that define your role. Are there things that by custom or just by recent experience have become a big part of what you have to do?
Yeah, there are. I get involved in part because my office is in Montpelier. I get involved in a lot of the legislative stuff.
Well, you served in the legislature one time.
I did. I served in the legislature for 6 years prior to becoming a judge.
That's terrific background for this job.
And so to the degree, a committee, mostly the House and Senate Judiciary Committees, need somebody to come and talk about the impact of a particular piece of legislation on the courts. I either will do that myself, or I'll find a judge who I think has had some experience in that area, and have them come and testify to the committee. I think it's really important that committees understand what the real life consequences are. And I know back when I chaired the House Judiciary Committee, that was very, very important part of the kind of fact-finding process that you have to go through before you decide exactly how you want that legislation to work.
I think communication is just a tremendous issue.
Right.
Because everybody's so damn busy. Everybody's working 24/7, and then you have to step back and say, oh, by the way, I just got to tell you this great story. When you had assigned me once up to St. Albans, so I'm doing juvenile cases, and I look up one day and there's this big guy in the back of the room, and these were public proceedings, and I thought, okay. So the end of the morning comes, the guy's still sitting there. So come back after lunch, the guy's still sitting there. So at the end of the day, I asked the court officer, would you find out who this guy is? It was Dick Sears. And what was he doing there? So I said, would you come up? You know, I said, what do you? He's the what is he? The head of the Senate Judiciary Committee.
He's been for a number of years now the chair of the Senate Judiciary Committee.
So he says, I'm here watching you. I said, what do you mean? He said, I want to see how you do this job. I said, oh, well, thank you very much. But I was very impressed. Very impressed because so many people, you know, I've testified in some recently actually one of these committees, and I was very impressed with how interested they were. That was very encouraging. But it must be overwhelming, the amount of information that that they have to consider.
Right. And much of what they're doing, of course, is either involves a court proceeding in some way or another. And you know, law of unintended consequences. Boy, I really learned about that when I was in the legislature. I mean, you think that you're doing something for exactly the right reason, but the result could be something that's quite different from what you intended.
Could be a backfire. Huh?
Another part of my job is definitely in that sort of collaborative, bringing people together. I'm a member of, the Chief Justice has two task forces. One is the Justice for Children Task Force, which looks at issues related to children who are in state custody, primarily children who are in state custody, but also delinquents, runaways, truants. We've kind of expanded our scope a little bit recently to look at also children who are in guardianship proceedings in probate, where guardianship is being transferred to a relative. And I also work with the Tri-Branch Task Force, which is the Chief's other task force, which involves the criminal justice system. And I know you and Karen spent some time talking about that task force. But the power to bring together, it's one of the things that judges can do and can do well. To bring together people who, to improve systems. And I take that part of my job very seriously. Now, do I have something written in a statute or rule that says I'm supposed to do that? No, but it's a natural part of this role.
Oh, I certainly agree with that. Just as an aside, the beginning of next month, Dr. Bruce Perry is coming here from Texas.
Oh, great.
He's going to give a one-day seminar on April 8th on the effect of childhood trauma in adolescence and later in life. I had tried real hard to get him on the show, but he's booked solid for both days that he's here. But there might be people interested in this. With the amount of, I'm sorry to say, physical and sexual abuse we have of children in this state, I think that we actually had made an agreement he was going to come in and talk about what he thinks the role of a judicial system can be in addressing the needs of these people who come to us as both perpetrators and victims. But we're going to have to do that some other time.
But, you know, actually that's a good segue into one of the areas that we wanted to talk about, which is the treatment courts, because...
Hey, that's right.
Hey, because, you know, I think treatment courts really get started in a way. Treatment courts are courts that are specialized around a particular problem. If you talk to judges who do juvenile work, who work with juveniles who are in state custody, in foster care, abused, neglected kids, runaways, truants, delinquents, you know, if you talk to the folks, in our state, we don't have that as a specialty, but there are many states that have that. That is all the judge does.
Oh, I know.
And those judges consider themselves the original treatment court, because they're looking at kids from the time sometimes they're, you know, 6 months old and come into custody all the way through until they reach some kind of permanency. And for some kids, unfortunately, never achieve that permanency. And so the judge is the one person that's kind of overseeing what's going on. And there are many, many players. And judges play that role of being able to bring those players together and look at systems and say, wait a minute, this isn't working right. Let's figure out a way to make this work better. I think drug courts came about because judges who were doing criminal work, and I'm sure you can relate to this, got tired of that revolving door. They got tired of seeing the same defendants keep coming in front of them, particularly on the substance abuse issues. And so they play a role. You can't create a drug court just because a judge says, I want a drug court. You got to bring treatment providers, attorneys, everybody who will be involved with that person around a table and say, okay, how can we structure something that might work better for this person? We have there are domestic violence treatment courts. There are treatment courts. There are child support treatment courts. But I think it mainly comes in part from that sort of proliferation comes in part from judges saying, wait, I see how this is working, and I see it over and over again, and I see these problems in the way the system is working. There's a better way to do this. If we come around the table and we talk about it, we can figure out something that will work better.
Well, I've tried in my last couple of years on the bench. I was sent to Burlington, then District Court, now the Criminal Division.
Now the Criminal Division,
yes,
right?
in the fall of 2009. And I saw all of a sudden, it was a revelation to me, the increase in binge drinking. And then Oxycontin, pills, Oxycontin, buprenorphine. This was really, it was a wave, big stuff. So that's why when I went back to the statutes and realized that I could impose treatment as a condition of release, we started that. And in the first 2 years, I think we referred, it wasn't just me, it was Judge Katz and some of the other judges in the district court. We referred more than 400 people to treatment. And
this is through the early assessment program.
Early assessment.
Yeah.
And it's really, I just published, there was an article I wrote that was just published in the Vermont Winter Bar Journal. And the overwhelming majority of the people who actually participated in treatment, we have very encouraging results. And I think it's just what you said. There are some things that the court is uniquely set up to do.
Right.
Because you've got some power and you've got some control. And if you call up and say, let's get, I made a bunch of phone calls.
And if you call a meeting, they will come.
And they come.
And they come.
Yeah, and they come.
And I think I think they are grateful for somebody sort of taking on that role, that leadership role of saying, okay, let's look at this and figure out a better way to do it. In the criminal courts, well, in all courts actually, but in talking about substance abuse issues in the criminal courts, it is really a triage process. We know that, for example, that of all of the folks who get, and I don't remember the numbers off the top of my head, picked up for a first-time DUI, that only about 20% of them will ever come back with the second one. So there's a certain amount, there's a certain number who with early assessment, getting appropriate treatment, not getting them too entangled in the criminal justice system, but getting them the treatment that they want and need, we can, you can increase that 80% probably to 85% maybe, because you've gotten, they've gotten the treatment that they need. Then there are the group that's a little bit harder to deal with, and then there's the group that's even harder, and then the group that's the 5% that are just really resistant to any kind of treatment at all. And so you have to have appropriate mechanisms, I think. The solution, in my opinion anyway, is not, we can't afford as a state to just simply lock them up. Number one, as Karen, I think, mentioned on your show the other day, they don't get any better, they get worse. We know that. And if you want to use incarceration as punishment, okay, fine, but understand that they're not going to get any better. When they come out, they will probably be more of a threat to public safety than they were when you put them in. And it's probably not going to act as a deterrent for others. I think we have this concept, I know I certainly did when I started looking at criminal justice issues, that, if we make the penalty really tough, people will say, I'm not going to have another drink, or I'm not going to get in and drive my car. Yeah, there's some who will do that, but probably not the people who end up as the DUI 3s, the DUI 4s, the DUI 5s. You have no impact on them in terms of deterrence, because they've got a serious substance abuse problem. Their craving for alcohol is going to way far outweigh any worry that they're going to get picked up.
Well, I think something you said earlier is worth repeating. There's no one solution that's going to fit every defendant. It's not one size fits all.
Right.
The thing that I was so encouraged about, and I told you earlier, I'm very much worried about this early assessment process that we started here in Burlington because of resources. But that costs a little less than $900 to get an assessment and to put someone through a course of treatment.
Right.
And the first kid, that a young woman from U of M, was the first person I put through this. And her attorney came to me, nice young man, and he said, you know, Judge, I'm here so often with people who get arrested once a month for 6 months. They're into pills and they're just stealing and they get arrested over and over again. And here is this person, you know, she was arrested, she was brought in front of me pretty quickly. And I had an appointment set up for her the next day.
Right.
And she completed this course with flying colors.
Right.
Hasn't been seen since, to my knowledge. One of the things I'm going to be fascinated in seeing is if it can happen, will be the follow-up and see what happens to like all the people who were referred in the first 6 months of 2010.
Right.
As a group, I think they're going to be followed to see how many people come back as recidivists.
Which is great.
Yeah.
Which is great. I mean, that's the thing that we really have to get. I mean, we really need to make sure that the programs we have are evidence-based, that they are actually accomplishing, that it's not just anecdotal, that they are actually accomplishing the goals that we wanted to accomplish. And unfortunately, that piece is expensive. I mean, people don't do that kind of research for you for nothing, understandably. But it is really an important piece. What I like so much about your program, the early assessment program, and in fact, I wish we had it, I wish we could have it everywhere in the state. But what I like so much about it is it really is evidence-based in this sense that we know, based on research, that the closer in time that somebody gets an assessment or treatment, the closer in time that is to the event itself, the more likely that they will get into treatment and the more likely that that treatment will be effective. If we wait until sentencing, we've lost the point. It's 6 months later, we just don't, you know, none of us have, it's human nature. You just don't have the same kind of motivation to fix the problem. You're kind of, well, you know, things are much better now. Now I've got this out of my way. Now I'm on to other things. And then, you know, I mean, you know, people come back with a second DUI within a year. Yeah. And you go, you just have to shake it. You know, what didn't you get about that first one?
Well,
but they don't.
They don't. Well, it's very funny. One day I was doing arraignments here, and a lot of details, but long and short was Brian Joyce is in the courtroom with a camera crew from Channel 3, and I didn't know what he was up to. I go home, I turn on the television. I had arraigned a kid, that 19-year-old fellow that day, driving at 3 times the legal limit, .24. Very bad driving, but fortunately no accident. So I said, you have an appointment tomorrow morning at 11 o'clock. This is the address that this is going to meet with, and you're going to be there, right? So the kid leaves the courtroom, and who's there? Brian Joyce with a mic right in his face. And it was a great day for me because Brian says to the kid, what do you think about what the judge just did? He said, I think it's a good idea because I've got a serious problem. And I never know who's going to react that way.
Right.
And the one thing that has always been an issue for me is, what's the role of coercion in getting people to take care of themselves?
Right.
And I never know who it's going to work for. And it doesn't have to be somebody who says, I know I got a serious problem, thank you, Judge. I'm not looking for that. No. I just want them to participate, you know?
But what would have been the likelihood that he would have said, yes, I know I have a serious problem, if he hadn't had to go for that assessment for 6 months? Yeah. A lot less, I think.
I think so,
I mean,
too.
I just think it's human nature that you, and there's evidence-based research to back that up. So, as I said, I would like to see early assessment. I think that it's more challenging in the rural parts of our state.
I wanted to, you suggested we should talk about this. I think you're right.
Yeah.
I mean, you know, I remember sitting in other counties where I'd want to have an early assessment. and it just wasn't going to happen. I had somebody who wasn't supposed to be driving now, and who's going to
Right.
take him or her to
Right.
an evaluation? Well, a couple of them I got them to go to evaluations, but then to go to treatment was really tough.
Judge Zimmerman, I was talking to Judge Zimmerman, who I know has been on your program and talked about the drug courts. She tried to replicate your program, having come from Chittenden, been assigned to Chittenden last year, and being quite familiar with your program. She is now the presiding judge in Windsor Criminal Division, and she tried to replicate it. And actually, that Connecticut River Valley area has a lot of services, but it's the lack of public transportation. And the court is in White River Junction. That's not where the substance abuse folks are. So it's a lot more difficult.
See, I was lucky in Grand Isle
Yeah.
because Charlie White, who's a licensed, alcohol counselor, he lives in the county, and he would actually go to the defendant's home. I mean,
pretty amazing.
it was amazing.
It's not
So
gonna-
I'd
that's
arraign the
right.
guy. I'd say, no, and you're going to call Mr. White. And you're going to do this and you do that, and he did it. And he did it. He was amazing. It was amazing because I could say to this person, you're going to go into Spectrum for an evaluation, and then you're going to see if they say it's appropriate. You'll go to Mr. White.
Right.
And of course, the thing I think should be said is, after there were assessments, not everybody was going to be treated.
Right.
Overwhelming majority, but this wasn't something a judge could decide.
Right.
When the
No.
statute said
No.
you can put him or her in an appropriate program, how do I know what's appropriate?
Right.
So I will rely on the professionals
Right.
to tell me.
Right.
But I know that the thing that's, it's everybody kind of, I'm sure, scratches their heads about this. When you're in a rural area and somebody comes in with one of these huge numbers or, 30 Oxycontin in the pocket, what are you going to do? It really is tough.
Yeah.
Really is tough.
Yep. No, I think that's true.
Well,
It is.
when we, and I know you can't answer this, and it's probably unfair, but I'm going to try it anyhow.
Oh, sure.
Okay. I'm constantly concerned about resources and where we are now in terms of the state budget and all the other things that, I'm very taken with the thought that the judiciary in Vermont is less than 1% of what the state spends. We're pretty much, we run a tight ship.
Right.
You run a tight ship. But that being said, those other facets, the social service agencies, corrections department, all these other people, I am really very worried about what's going to happen here. And is there, what do you think? Do you have any notion as to what's going to go on?
No, I think that, I think it's tough. I don't. And I think it's going to come at us both at the state level and at the federal level, and it's going to come at us at the same time. And it's going to be pretty rough. And nobody is saying that we're going to recover from this very quickly. I think that could we be delivering programs more efficiently and effectively and more cost effectively? That's probably true. And to some degree, it may force us into figuring out ways to do things in a more cost effective fashion, and that may over the long term be productive. But to the degree that it wipes out programs like wipes out eligibility, Medicaid eligibility for a substance abuse assessment, for example. We're being penny wise and pound foolish. The price that we will end up paying if those folks don't get the early assessment, the price we end up paying over the long term is huge, including that they're going to get in the car drunk someday and they're going to hit somebody and kill somebody. But ultimately, even if that doesn't happen, some of them, not all of them, but some of them will be back in front of the court and someday judge will just throw up their hands and say, right now, that's all I can do is just incarcerate you. And that's what's going to happen. And what we don't what we don't provide for the public, I think, is what's the cost of that? I mean, every time we do that, if you can project out how many people that's going to impact, and then you do the cost analysis, the corrections budget eats up. I mean, the push in the legislature over the past couple of years, going back to Justice Reinvestment at the Council of State Governments, which started really back in 2005. The push in the legislature has been, how can we slow the growth of corrections, because it's eating us alive. And if we don't slow that growth, we will end up having it, even without an economic downturn, it will gobble up everything around it in terms of resources. Now, I mean, I'm not suggesting that, I mean, there are certain people that need to be put away, and they need to be put away for a long time. And those are people who are really a threat to the public, and there is not much of anything that you can do. But to spend, how much did Karen say, a year per day in the correctional facility? She had a figure on your program, and I can't remember what it was, but it was...
I think it was $23,000.
It's something like $23,000. Yeah. To spend $23,000 a day to make somebody worse, make a drug addict worse.
I should ask you about this. When I first came up here 20 years ago as a public defender, I have a very strong impression that there were more treatment programs inside than there are now. There was more trying to work with people who with alcohol and substance abuse issues. Certainly there was, and there still is, of course, an effort with the sex offenders.
Right.
But has there been a reduction in the amount of, treatment for incarcerated persons? I assume they can't get this when they're in Kentucky or wherever else we send them.
If they're incarcerated, they are not getting treatment other than at the work camp. I think they're at the work camp. They currently, that's relatively recently, but they currently do have some alcohol treatment programs there. But other than the work camp,
I found that to be discouraging because I didn't have that option anymore when I was sentencing some people. And it's just terrible things.
Yeah.
It's just terrible. Well, I mean, you sit up there and you think, what did this poor person do? Well, like this poor young woman who got killed in Burlington. I mean, you're innocent going about your business. I mean, come on.
Oh, yeah. No, I know. I think those are probably, from a sentencing perspective, the DUI fatalities are and the DUI substantial injury cases are probably the most difficult. I just testified recently in front of the House Judiciary Committee about this. And from a sentencing perspective, because often on the DUI fatality, actually we looked at the figures going back to 2005, I think. Number one, it wasn't a long list.
No, it's
not. I mean, it was like a list about that long. And most of them, there were very few DUI 3, DUI 4 plus, most of them, DUI 1, DUI 2, and it's 16, 17, 18-year-old. That's what most of them are.
Well, I've said for a long time, I'm very committed to the idea we should have evidence-based decisions, not just what you feel in your gut that day.
Yeah.
And particularly with the DUI cases, I've come around to the point of view that, on a DUI too, there ought to be some incarceration, not because I know
wake-up call.
Yeah, there should be something because, I remember when I first came up here, when I faced a felony DUI case, often there had been no punishment on 1 and 2, and on 3, there are a lot of judges who said that's 1 to 5 to serve.
Yeah, right.
And I thought, hey, what are you doing?
Yeah.
Let's have a little bit of gradualness here.
Right. Right. No, I think that's right. And I think sometimes that wake-up call, that short hit, can be very powerful, and it's used that way. And just going back to drug courts for a minute, that sanction of the short jail hit. Every time you kind of deviate from what you're supposed to do, what the expectations are for what you're supposed to be doing in the program, it's extremely effective. the threat of jail, the immediate threat of jail, is an incredibly effective behavior modifier, at least for the duration of the program.
Well, you were mentioning to me earlier when we were talking that the drug courts really are most effective with persons who have problems with drugs. Not to say, I know, was it Representative Lippert corrected me recently when I said drugs and alcohol. He said, alcohol is a drug. I said, yes, sir. And it is, of course.
Right.
But it seems to be a different pattern between treatment of people with alcohol problems and treat people with problems with pharmaceuticals, with prescriptions.
Well, the chemistry of their addiction is different. I mean, just to start with, the chemistry, and I think that that's something that we have learned a lot about in the last 5 or 10 years with all of the neuroscience and brain research that's been going on. The chemistry of their addiction is different. So it's addiction in both cases, but what we're dealing with in terms of the chemistry of their addiction is different. And some of the behaviors are different. I think that in both cases, if you the group process is extremely effective. In drug court, that group process is that group of folks who are in the drug court who are always there in the courtroom when you are either getting admonished and they, or you're getting praised. And when you're getting praised, and it's somebody who, I mean, the guys in the drug court, guys and women, will stand up and cheer for you.
And they
because
know
they see that you've
they're
done
there.
you've done something and you are become role models for each other. The same thing happens in group programs in alcohol, but I think that for people who are alcohol dependent, but I think that people tend more to respond to somebody who has also got the alcohol problem because you know what I'm talking about. And you're going to be able to catch me better when I, you know, kind of like skim the truth a little bit, so to speak. And I think the same thing is that, you know, if you're somebody who's addicted to drugs, particularly the same type of drugs, you know how that other person thinks. So I think they are absolutely both drugs, and they are both addictive. But an addiction.
So there's now in terms of supervision, there's the intensive substance abuse program, ISAP program,
right?
And that's basically being used for alcohol.
I think so. Although I think in courts that don't have a drug program, it may also be used for drugs. But I think it's particularly effective with the alcohol folks. And I think that in counties where you have a drug court, that the drug court works better. In fact, normally they don't refer anybody with alcohol issues. They only refer drug folks, and they need more structure. That business of having to come to court every day, or not every day, every week, is very powerful. It has a very powerful influence on getting people to change their behavior. And having a judge who sat in judgment of you say to you, "Wow, Ben, you have done an incredible thing. You went out and you found an apartment for yourself, and you got the deposit together. This is something to celebrate." That's very important.
I saw Jim Crescetti do this years ago, and he is a master.
He's a master. Right?
He is a master. He is so good at this. And this young woman had a world of trouble, and it was really sad what had happened to her. And he hung in there with her, and every once in a while had to punish her, and she is a tremendous success now.
We're very fortunate in Vermont that we have some judges who are very good at this. We have other judges who don't want to touch it. It is social work. It is not what I got on the bench for. I want to come on the bench. I want to decide a case. That's my job. And that's okay. We need a mix. But the judges who have an affinity for this kind of work, I think it can be tremendously rewarding. Much more rewarding than watching people go through the revolving door.
Oh, amen. Amen. Yeah. Well, I think I've done my outline here, Judge. Let's see what else. What have I forgotten? We talked about, oh yes, I just want to be clear on this. When someone's in a drug court program, they've been convicted of a crime and they're on furlough. Is that right?
They have been convicted, no, they have, mostly they have, it's a post-plea program.
Okay.
But their sentence is hanging over them still. They haven't gone to sentencing yet. And so, but the judge has the ability to give them, to incarcerate them for.
So the judge can put in short hits. The judge can say, I'll see you next week.
Absolutely.
And you're going to be.
Absolutely. That's the part of the sanctions. The sanctions go everywhere from, you know, standing up and apologizing or writing an essay, or all the way to a stay in jail for a day or 2 days.
We had on the show, we had a woman who was completed the drug
Graduate,
court program.
yeah.
And she inspired me. I mean, she was really something.
Yeah.
She had had a world of trouble. And she went through the drug court with Judge Zimmerman. And I know I talked to Pat after I did the interview, and she remembered everything in detail, of course, and was very pleased. I think it is a very gratifying thing for a judge to do.
Well, I mean, you have, in fact, you have folks who say to you, thank you for putting me in jail. It was the right thing to do. I needed to, you gave me the right sanction at the right time. Nothing better than that.
I once knew this great judge up in New Jersey, federal judge, Al Wolin, and he once told me that some big strapping guy stopped him on the street, and he was a little nervous, didn't recognize him. The end of the story was, I want to thank you, Judge, for putting me in jail for 2 years. Huh?
Yeah.
And we talked, and this had been just a chronic bad drugs and crime. And the guy had straightened himself out, and he was doing better.
Pretty impressive.
I've had that with people I've given short hits to who have done the 10, 20, 30 days in jail, and it's worked.
Yep.
You know, it's worked. I think, but I got people disagree with me about this, and I think I have to concede that often the fear of being put in jail is more effective than actually putting people there.
Absolutely. I mean,
that's why the judge has a unique role.
That's right. That's right. We have a domestic violence court down, and it's not really a treatment court, but it's an integrated domestic violence court where domestic violence offenses and the relief from abuse process kind of come together. There's some case management in terms of putting together good plans as far as visitation with kids and things like that.
Which county is this?
This is in Bennington. This is Judge Sontag's program. But Judge Sontag is a big believer also in the short hit, you know, on the violations of probation, bringing that violation for even a minor misstep, and a short hit. Doesn't have to be long, but that can. There's a lot of debate about that right now.
I know, that's why
there's a whole.
I don't mean to be unfair to you, but I know there's a lot of dispute about it.
There is a lot of dispute right now. And in fact, the legislature has been going back and forth about this as well, as whether short hits are a good thing or not, or a bad thing.
Yeah. Well, you know, I mean, I have never been a proponent of incarceration for a first offense DUI, but I'm always worried about formulas. You know, there may be a first offense DUI where incarceration is the appropriate thing to do.
Right.
You know, you just,
Right.
I hope that because of concerns about these social issues, we won't get around to, well, like the federal sentencing guidelines, which I think were a catastrophe and resulted in long periods of incarceration,
Right.
which were really very destructive.
Right.
A lot of those guys who finally got out they were never going to be right. You know,
No,
so
they're going to be way worse than.
Went to postgraduate school for crime.
Yeah,
you know,
absolutely.
That's a shame.
Absolutely.
Amy, I want to thank you very much.
You're very welcome.
It's really been a pleasure.
It's been a pleasure.
I only wish, you know, I don't know where this little show of mine will go, but I think it's very important that the public should hear from someone like you to understand the concern and the effort that's made to try to treat these problems. I think so many of us live in a little bubble that we don't get a chance to look outside. And that's frankly, that's one of the things I'm hoping to do here, is that it'll give the public some opportunity to see who's doing all this important work.
Well, thank you, and it's been a great pleasure.
Thanks.
Good conversation.
Sure.
Thanks.
Bye-bye.